If you woke up this morning thinking your immigration status was secure, you might want to sit down for this, because what just happened in February 2026 has sent shockwaves through immigrant communities across the entire United States, and the changes are affecting millions of people in ways nobody expected. I'm not trying to scare you, I'm trying to prepare you, because right now, as you're listening to this, new rules are being implemented that could fundamentally alter your path to citizenship, your work authorization, your family sponsorship plans, and even your ability to remain in this country legally. The phone lines at immigration attorneys' offices are ringing off the hook. Community centers are flooded with panicked families trying to understand what these changes mean for them. And the sad truth is that most people don't even know these changes exist yet. They're going about their daily lives completely unaware that the ground beneath their feet has shifted. So let's break this down together. Let's talk about exactly what changed, who is affected, and most importantly, what you need to do right now to protect yourself and your family. First, let's talk about what triggered all of this. The Department of Homeland Security announced a comprehensive overhaul of immigration processing procedures that went into effect at the beginning of February 2026. This wasn't a single rule change. This was a complete restructuring of how applications are reviewed, how interviews are conducted, and how decisions are made on everything from green cards to naturalization. The official reasoning behind these changes was to reduce backlogs and improve processing times. And while that sounds wonderful on paper, the reality of how these changes are playing out is far more complicated. Some applicants are finding their cases accelerated, while others are discovering that new requirements have essentially reset their entire application process. Let's start with green card applicants, because this is where some of the most significant changes have occurred. If you currently have a pending employment-based green card application, you need to pay very close attention. The new rules have introduced additional documentation requirements that apply retroactively to pending cases. That means even if you submitted your application months or even years ago, you may now be required to provide supplemental evidence that didn't exist as a requirement when you first applied. These new documentation requirements include updated employer verification letters that must be dated within 60 days of your interview, enhanced financial documentation showing a longer history of employment stability, and in some categories, new skills assessments that must be completed by approved third-party evaluators. If you don't provide these documents when requested, your application could be denied outright. Now here's where it gets really concerning. The window to respond to these supplemental evidence requests has been shortened dramatically. Under the old rules, applicants typically had several months to gather additional documentation. Under the new framework, you may have as little as 30 days to compile everything and submit it. For people who need to obtain records from overseas or who work with employers that move slowly on paperwork, this compressed timeline could be absolutely devastating. Family-based immigration has also seen major changes, and if you're sponsoring a relative or waiting to be sponsored yourself, you need to understand what's different now. The income requirements for sponsors have been revised upward, and the methodology for calculating household income has changed. Under the previous system, sponsors could include income from household members who signed an affidavit of support. The new rules place more emphasis on the primary sponsor's individual income and give less credit to supplemental household contributions. What does this mean in practical terms? It means that some sponsors who previously qualified to bring their relatives to the United States may no longer meet the threshold. It means families that have been waiting years for their priority date to become current might find themselves ineligible under the new framework. And it means that if you were planning to file a family sponsorship petition in the coming months, you may need to completely reassess your financial strategy. The changes to visitor visas and tourist entries have also caught many people off guard. If you have family members who regularly visit you from overseas, or if you yourself travel internationally and return to the United States, you should know that the scrutiny at ports of entry has intensified significantly. New screening protocols have been implemented that give border officers expanded authority to question the intent and duration of visits. There have been numerous reports of travelers being held for secondary inspection at much higher rates than before. Some visitors are being asked to provide proof of return tickets, hotel reservations, and detailed itineraries before being granted entry. Others are being questioned extensively about their ties to their home country and their reasons for visiting the United States. While these measures are being described as security enhancements, the practical effect is that entering the country has become more complicated and more stressful for many legitimate travelers. Now let's discuss work authorization, because this is an area where the changes could have immediate consequences for your daily life. If you hold an employment authorization document, commonly known as an EAD card, the renewal process has been modified in ways you absolutely need to understand. The automatic extension period for pending EAD renewals has been adjusted, and the eligibility criteria for certain categories of work authorization have been narrowed. Previously, if you filed your EAD renewal application before your current card expired, you would receive an automatic extension of your work authorization for a certain period while your renewal was pending. This allowed you to continue working legally even if processing delays meant your new card didn't arrive before your old one expired. The new rules have modified how this automatic extension works, and in some categories, the extension period has been reduced or additional conditions have been attached. If your EAD is expiring in the coming months, you need to file your renewal as early as possible. You need to track your case obsessively, and you need to have a backup plan in case your work authorization lapses before your new card arrives. Employers are legally prohibited from allowing you to work if your authorization expires, even if your renewal is pending. This is not a situation where you want to cut things close. The naturalization process has also been affected by these February changes, and if you're on the path to citizenship, there are new considerations you must be aware of. The good news is that the basic eligibility requirements remain the same. You still need to have been a permanent resident for the required period, you still need to meet the physical presence requirements, and you still need to demonstrate good moral character. However, the way applications are being processed has changed. There is now increased emphasis on verifying travel history, and applicants are being asked to provide more detailed documentation of any trips outside the United States. If you traveled abroad for extended periods during your time as a green card holder, you should be prepared to explain those absences and provide evidence that you maintain continuous residence in the United States. Additionally, the civics and English testing components have seen some modifications. While I don't want to alarm anyone unnecessarily, there are reports that the testing procedures have become more rigorous, and that examiners are being instructed to apply stricter standards when evaluating responses. If you have a naturalization interview coming up, extra preparation is strongly advisable. Let's also address the Deferred Action for Childhood Arrivals program, because DACA recipients have always faced uncertainty, and these new changes add another layer of complexity. If you are a DACA recipient, your ability to renew your status depends on the ongoing legal status of the program itself, which continues to face challenges in the courts. The February changes include new administrative procedures for how DACA renewals are processed, and there are reports of increased scrutiny during the renewal review process. My advice to DACA recipients is the same advice I would give to anyone in a precarious immigration situation right now. Document everything. Keep copies of every piece of correspondence with immigration authorities. File your renewals as early as possible. And if you haven't already, consult with an immigration attorney who can review your specific situation and help you prepare for any contingencies. Speaking of attorneys, I want to take a moment to address something critically important. In times of immigration uncertainty, there is always an increase in fraudulent practitioners who prey on vulnerable immigrants. These individuals may claim to be lawyers when they are not. They may promise results they cannot deliver. They may charge excessive fees for services that are available at much lower cost or even for free through legitimate organizations. Please be careful about who you trust with your immigration case. Only work with licensed attorneys or accredited representatives from recognized organizations. Verify credentials before you pay anyone anything. And remember that no one, no matter what they promise, can guarantee a specific outcome in an immigration case. Anyone who tells you otherwise is lying to you. Now, I know this is a lot of information, and I know it can feel overwhelming. You might be sitting there wondering what you're supposed to do with all of this, how you're supposed to navigate these changes when everything seems so complicated and the stakes are so high. Here's what I want you to do. First, take a deep breath. Panic is not going to help you. What will help you is taking calm, deliberate, informed action. Second, gather all of your immigration documents. Make copies of everything. Know exactly what your current status is, when your documents expire, and what deadlines you're facing. Third, create a timeline. If you have pending applications, know exactly where they are in the process. If you need to file renewals, know exactly when you need to file them. If you have interviews scheduled, know exactly what documentation you need to bring. Fourth, stay informed. These changes are still being implemented, and there may be updates, clarifications, or additional modifications in the coming weeks and months. Follow reliable news sources. Check the official USCIS website regularly. Join community groups where accurate information is shared. Fifth, if you have any doubt at all about how these changes affect you, consult with a qualified immigration attorney. Many organizations offer free or low-cost consultations, especially for people facing urgent situations. Do not try to navigate complex immigration issues on your own if you're unsure about anything. I also want to speak directly to those of you who are not immigrants yourselves but who have immigrant family members, friends, coworkers, or neighbors. The people in your life who are affected by these changes may be scared right now, they may be confused, they may feel alone and unsure of who to trust. You can help by being a source of support and accurate information. You can help by connecting them with legitimate resources. You can help simply by letting them know that they are not alone and that people care about what they're going through. Immigration has always been a complex and often confusing system, but the changes we're seeing in February 2026 represent a significant shift in how that system operates. Some of these changes may ultimately be positive, leading to faster processing and clearer procedures. But during this transition period, there is enormous potential for confusion, mistakes, and people falling through the cracks. Don't let that person be you. Don't let that person be someone you love. Stay informed, stay prepared, and most importantly, take action before deadlines pass you by. If you found this information helpful, please share it with others who might be affected. There are people in your community right now who have no idea these changes exist, people whose lives could be dramatically impacted if they don't find out in time. And make sure you're subscribed to this channel because I'm going to be covering every development as it happens. Whenever new guidance is released, whenever court decisions affect these policies, whenever there's anything you need to know to protect yourself and your family, I'm going to be here to break it down for you in plain language that actually makes sense. The next few months are going to be critical for millions of immigrants and their families across this country. Knowledge is your best defense against uncertainty, and right now, more than ever, you need to be armed with as much knowledge as possible. Stay safe out there, stay vigilant, and I'll see you in the next video.